Welcome to Feminist Question Time, brought to you by Women's Declaration International, the leading global organisation defending women's sex-based rights against the threats posed by gender identity ideology. Our programme today is, we're going to first of all hear from Dawn Furness, who is at the Green Party of UK conference right now, and she's in an organisation, Green Women's Declaration, which is doing a fantastic job promoting women's sex-based rights. She's going to give us a little report of what's going on, what the Green Women's Declaration are doing, what's happening at the conference, or something. Then we're going to hear from Kenia from Mexico. The title of her talk, Kenia's from Mexico, Lesbian Impossibility, is a strategy that patriarchy has used to control our being, one of the most atrocious weapons against women. And I'll introduce her more fully when she speaks. Then we're going to hear from Sharon Byrne, who is the executive director of WOLF, about an open letter to United Nations Women that she's been involved with and WDI has been focusing on and promoting. Then we're going to watch a video from Anna Kerr, which was just made a couple of days ago, about the Tickle versus Giggle case in Australia, which gives you a really clear update on what happened. And that's so. And we will also show the short report that we tend to always have these days, which is brilliant, from Kari Bruss from the United States. How's it going? What are you doing? What's happening? And where are you?
Hi. Hi, Joe, and welcome to Manchester Central, where I'm standing outside the National Green Party of England and Wales conference. And I'm here with a women's organisation, the Green Women's Declaration, and also the Greens in Exile group, who are standing behind me. If we give them a quick cheer. Hello, everyone. Say welcome to the conference.
Yay.
How is everyone doing?
Yeah, great. So there's like 123 of us in the webinar. Well, 130 of us actually watching. So yeah.
So the Green Women's Declaration was a signatory petition that members of the Green Party signed in August 2023, which was to assert women's sex-based rights under the 2010 Equality Act. Now, this was because the party was not recognising sex as a protected characteristic, despite the act and despite several litigation campaigns that were discriminating against women. Now, because of this, we've had over 1,500 signatories of the declaration, including several high-profile members, including Jonathan Porritt. And this was to assert women's rights and to say that we could organise within the Green Party as members and have freedom of speech and freedom of association within the party. Now, as a consequence of signing that declaration, 5 co-chairs of the caucus to represent women's rights within the Green Party have been expelled from the party. 5 consecutive co-chairs of Green Party women, myself included, and also my former co-chair, Emma Bateman, who was also taking legal action against the party. We've come today to represent Green Women's Declaration, and also Greens in Exile, to try and raise awareness as to why the party is purging predominantly women for talking about sex, despite the fact that it is a protected characteristic under the Equality Act, and also despite the fact that other political parties, including the Liberal Democrats, recently lost very high-profile cases against their own members for exactly the same discrimination. Now, we are raising awareness of this issue, and the problem is most people in the party don't even know this is actually happening. And this is the first time we've actually had an assembly of a significant strength outside the organisation, outside the conference that's happening inside this very room behind me. And we've had an awful lot of positive press, including several of the national broadsheets, Sky News. We've had reports on BBC News, 6 o'clock news, the national news last night. And there was more focus on our hashtag Greens in Exile than there was on the actual parliament and the actual conference itself. And we're very proud that the message seems to be finally getting through that they cannot expel and suspend women purely on the basis of their sex class. Most of the delegates have absolutely no idea that this is happening behind the scenes. They see it as, it's been explained to them or presented by the party as a factional rights issue, where it's 2 groups have an communication issue, when it's not the case at all. This is a women's rights issue, and it's also about freedom of speech, and as I said, freedom of association. the party has taken an extraordinary authoritarian line on this to stop women even talking about it. I myself presented a motion to the conference in September 2019 to have the word sex included in the National Party Rights and Responsibilities section. And that was not only not heard on the floor of the conference, but I was assaulted by a man from the LGBTQ IQA plus Greens for even having the audacity to put that motion to the floor of the conference. Now, all the things that are associated with the expression of women talking about sex and the discrimination, the harassment and the violence against women, this is now culminating in multiple court cases, which will inevitably bankrupt the party. So what we're trying to do, all the women who are involved in this campaign are hardcore grassroots environmental campaigners who want to protect the planet against climate change, want desperate action to take action on the climate emergency. And yet they are purging their own members at an extraordinary rate. Only this week, they suspended their own EDI officer for asking the wrong kind of questions. And they also suspended their health spokesperson for saying that she supported sex-based rights for women. And she was prepared to defend that, which is an extraordinary position for any party to take. It's authoritarian, it is non-democratic, and it's absolutely not what the Green Party is supposed to stand for. If anyone wants more information, they can go to the greensinexile.org.uk website and also to the greenwomansdeclaration.uk. Thank you very much and welcome back.
So we're now going to hear from Sharon Byrne. So Sharon Byrne is the executive director of WOLF, and she has been coordinating and promoting, along with some other women's organisations and with some support from WDI, an open letter to UN Women. And so Sharon, could you tell women about what the letter is, why it's necessary, and what you're hoping to achieve from it?
You see what women can do, and that this is exactly what we should be doing. So I have a very inspirational story to tell you too. I'm going to frame it in the context of the Demotivational series. If you haven't seen them, these are a series of posters, go look them up, done by Gen Xers who are just sort of pissed off at the world. And one of them, which is one of my favorites, is a picture of a snowball going down a hill and turning into an avalanche. And the caption on here is, never underestimate the power of what two snowflakes can do working together. So I'm setting that context up because one of my partners in crime here that I adore is Clarice from Matria in Brazil. And I met her last October. She reached out to us. We immediately turned around and hosted a call with Reem Al-Salam, the Special Rapporteur on Violence Against Women and Girls at the UN. It was a great evening. I was really glad that we did it. So Clarice reached out to me about a month and a half ago and said, hey, did you see this post by UN Women? And I should confess to everyone, I am a delegate to the Conference on the Status of Women in New York. I will tell you that at that conference, 10,000 women have very deep conversations about things like female genital mutilation, land for women to farm so they can exist, femicide, child marriage, etc. Right? Like very deep, serious, like major conversations. Trans is just not a thing at the Conference on the Status of Women. It's just not. But UN Women has very much taken up the call. And Joe hosted me back in July at the WDI conference in London to speak about why the United Nations has been so captured. And it has a lot to do with UN Women, who unfortunately are funded heavily by my government, the United States, who is pushing this agenda. So when Clarice reached out to me and said, we want to talk about this. And I said, okay, let's talk about it. What do you want to do here? She said, we have to do something. We have to get UN Women just, they've gone too far. They put out something in June for Pride Month that basically called all of us anti-rights, far-right bigots, all of us, the gender critical women who did not accept trans into their spaces and who did not believe in gender ideology, that we are all anti-rights, which is absolute bollocks, and we all know it. So we tossed around a couple of ideas. What should we do? Do you want to host a worldwide call with Joe and get a bunch of women on and, really scream about it? Do you want to do a video about it? What do you want to do? We finally decided the thing to do is an open letter to UN Women. And we looked through their mission, which their mission is a good one. They were started in 2010, and their job is the empowerment of women and girls to achieve true equality. I think we would all agree with that mission. I think we would not have a problem with that mission, but they are way far away from that mission, way far away. So Clarice took the initiative to draft up the letter in Portuguese and translate it into English. And then Joe and I cleaned it up a little bit and got it sort of ready for English speakers. Then Clarice took it and put it into Spanish and French and others. So we reached out to Joe And I said, look, I'll contact a lot of the American women organizations. I'll contact some of the Canadians, some of the Anglosphere organizations. Joe, can you help us out? Because, you know a lot of them, you host them on this call every week. She said, oh yeah, I'll get it out. Clarice reached out to Brazilian organizations. Amparo then took it, went to Spanish organizations. A friend of ours that runs a lesbian group, she took it and got it to a bunch of other lesbian groups. Suddenly Germany starts signing on. Australia, New Zealand got hold of it. Canadian org started organizations I've never heard of. I've never heard of them. And I think Joe had not even heard of some of these. And they came on from all over the world and gave us their logos and said, put me on this letter. So when you now look at the letter, which Clarice has done a good job putting it down here for you, so you can see it, and you see all those women's organizations signing on and kicking back against UN Women and saying, you've lost your way. You've lost the plot, you've lost your way. Get back to your job of empowerment of women and girls and getting us equal, and get off of this shtick. This is really bad. So it's impressive to see that list of women's organizations from around the world. And you've got to realize, if you're sitting there at UN Women and looking at that, wow, they can't all be wrong. All these women can't be wrong. So then Clarice made it so that you could actually sign the letter individually as well. So not only did we have all these women's orgs that signed on officially, individuals could add their signatures too. So we sent out an email blast to Wolf members in the middle of this week, and like overnight, 1,000 signatures went up on that thing. We started, Clarice originally wanted, I think, 3,500 signatures on it. We have blown past 4,200 signatures as of this morning. And the new goal is 5,000 signatures. And Clarice is a freaking genius because she set up the website. We got a bunch of email addresses. Our friend Anna helped us out. When you sign this website, when you sign onto this letter, it kicks off a bunch of emails to UN staffers. So they're getting all of these emails from all of us saying, for the love of God, turn it off, right? Like, stop doing this, right? So we basically, I don't like to use this terminology in United Nations speak, but we are basically at war with UN Women and have let them know, like, you've got to do better than this. Then we went one step further in the United States, because my country is the one pushing it in the United States. And I have a great ambassador to the United Nations. It is Linda Thomas Greenfield. And she normally is all that and about. She's very, very competent. She's very capable. She has extensive experience in human rights, particularly in Africa. So she should have been a fine UN ambassador to the United Nations from the United States. But last year in March, she called a special meeting with the UN Security Council. This is the most important body inside the United Nations. These are the people that worry about ceasefires. These are the people that worry about, global unrest and conflict. And she called the special meeting and said, we're going to incorporate LGBTQI concerns into everything we do. And China, Ghana, Russia, and other countries said, no, we're not. This is absolutely the wrong place to do this. So remember, the United Nations is made up of member states. So we put in a request to US supporters, please use the United Nations, the ambassador to the UN's website, and contact Linda Greenfield Thomas and let her know American women are not good with pushing this ideology at the UN. What we're hoping to do is apply a pressure wedge where she would then have enough emails coming from American women saying, cut this out, that she would be able to turn to our government and say, stop asking me to push this. The public's not with us on this. Don't stop it. Just stop it. So Clarice liked this idea too and pushed it out on social media. And we've had quite a few letters come in to Linda Greenfield Thomas saying, stop it, just back off of gender ideology. We are not with you. And you need to quit pushing this at the United Nations. And what we're hoping is that other countries will follow suit, that they will reach out to their ambassador to the United Nations and say, as a citizen of Austria, Canada, or Brazil, stop this. We're not on board with this. And then that will give them kind of a relief valve to be able to turn to their own government and say, our people are not with us on this. Quit asking me to do this. Quit asking me to push this at the United Nations. So I'm really tickled that out of literally an afternoon call between myself and Clarice that we then dragged Joe into, this has turned into this worldwide effort with all these thousands of women signing on. And that's why I want all of you to be very inspired and just say to yourself, like, one woman can, right? Like one woman can, or three women can in this case, kind of really start to apply pressure and turn the situation around. And this is exactly what we need to be doing. We need to do this. We need to be able to put this pressure on, and really get our governments to understand that we're half the population and we're not with you on this. Cut it out, back up and do the right thing here. So Joe, thank you for letting me come on. And I see Clarice is here and she's been putting things in the chat, and I'm so proud of her. She's run a whole social media campaign on this. It's been really good. And thank you, Joe, for taking this and getting it to all kinds of women's orgs around the world for us that you're in contact with, that then blew my mind and shared it to all their friends in their countries, right? And shared it to other women's orgs in their countries that I don't think either one of us had met. And so, yay, we now have this global coalition. So Clarice, of course, has turned around and said, do you want to do the same thing with Amnesty International? Yeah, I think we're going to pull this out again and again and again now that we have this group, right? Like we have a route now, and a really good worldwide group that I think these voices could be raised in many, many efforts. So thank you.
Absolutely.
I'll start with some big news that just was launched today. WDI USA joined other women's groups in filing an amicus brief in the Sixth Circuit to prevent the illegal Biden-Harris Title IX rewrite from taking effect in Tennessee, Indiana, Ohio, West Virginia, Kentucky, and Virginia. The filing's press release includes Elizabeth Chasak's first public quote as president, and it reads, "Gender identity does not exist in any real material sense, yet the Biden administration insists on pretending that it does. WDI USA works to advance the Declaration on Women's Sex-Based Rights, which is grounded in radical feminist principles throughout US law and society. Article 7 of the Declaration reaffirms women's rights to the same opportunity as men to participate actively in sports and physical education. Sports are played with bodies, not gender identities. WDI USA is proud to unite with women's groups across the political spectrum in standing with the plaintiffs in their fight to preserve the original intent of Title IX. Moving on, House Republicans are investigating whether the Biden administration, specifically Assistant Secretary of Health Rachel Levine, pressured WPATH to do away with age limit guidelines for so-called gender-affirming treatments, including surgeries for minors. The House Committee on Oversight and Accountability is investigating allegations of potential interference by the U.S. Department of Health and Human Services in third-party medical organization recommendations, according to a letter sent by Rep. Lisa McClain to the chairwoman of the Subcommittee on Healthcare and Financial Services to HHS Secretary Javier Becerra on Tuesday. And I can put a link in the chat to that, and the link includes a link to the letter. This week, the 11th Circuit Court of Appeals ruled that Florida law banning the medicalization of minors distressed with their sex may be enforced in the state while a lawsuit works its way through the courts. The Federal Appeals Court also refused to reconsider a decision allowing Alabama to enforce its ban, declining a request by families with trans-identifying children that the full court reconsider the earlier three-judge panel's decision to let the law go into effect. On August 26, 23 states, led by Missouri Attorney General Andrew Bailey, signed on to an amicus brief with the Supreme Court, arguing against the medicalization of minors due to a lack of evidence of their safety. The brief is in support of North Carolina and West Virginia, states that have appealed to the U.S. Supreme Court to overturn a Fourth Circuit Court of Appeals decision that state health insurance plans must provide coverage for so-called gender-affirming care. Of note, the Cass review is one of the citations listed in the brief. A proposal to amend the Equal Protection Clause of the New York State Constitution to include gender identity and gender expression as protected characteristics, along with other additions that imply but don't explicitly protect access to abortion, is expected to be on New York ballots this fall. Prop 1, per cara, is manipulating women into voting for a law that would obliterate female-only sports and spaces and establish a constitutional right for minors to sterilize themselves. The New York Constitution currently protects against discrimination based on race, color, creed, and religion. The proposal would add protection based on ethnicity, national origin, age, disability, sex, sexual orientation, gender identity, gender expression, pregnancy, and pregnancy outcomes, as well as reproductive health care and autonomy. Of course, any objection to the proposal is being labeled right-wing. And that's all I have for today.
So we're now going to hear from Anna Kerr, who's the WDI country contact in Australia.
So I'm going to be talking about the case of Tickle and Giggle, which I'm sure everyone's already heard an awful lot of commentary on this case already. So I'll be talking very specifically about the decision, and if I use certain language that bothers you, it's probably because I'm quoting from the judgment. I'm just giving that warning. So this decision's just been handed down in the last, what is it, a week? Feels an eternity. So just to go over quickly, I'm sure most of you are familiar with these facts. This is the case involving Giggle and Sal Grover. So Sal Grover, having experienced sexual harassment and sexual assault during her 10 years as a screenwriter in Hollywood, decided with the support of her family that it would be therapeutic to set up a social media app exclusively for women and girls. And the app was specifically designed to enable women to meet safely online and network free of male harassment. It was, of course, under attack on a regular basis from males who attempted to register. But despite all that, it managed to accumulate about 20,000 users by 2021. Now, Roxanne Tickle, who's the applicant in this case, was a person who had various genital surgeries in October 2019. And then in accordance with Queensland law, Tickle's birth certificate was reissued with a female sex marker on the 18th of September 2020. These are facts taken from the judgment, by the way. In 2021, Tickle registered as a user with the Giggle app, having passed the gender detection system, only to be subsequently blocked and excluded some months later during a manual review of user profiles conducted probably by Ms. Grover herself as CEO of Giggle. And Tickle was at that point identified by Ms. Grover as being male. So Tickle then made complaints, sent emails and calls to Ms. Grover that weren't really responded to, and so then lodged a complaint with the Australian Human Rights Commission in December 2021. Tickle alleged discrimination on the ground of gender identity in the provision of goods and services. So this involves the joint operation of Section 5B and Section 22 of our Sex Discrimination Act, which is a federal piece of legislation. So as there was no prospect of conciliation, the Commission terminated the complaint, which then left Tickle with the option of taking the matter to the federal court, where the claim was ultimately heard by Justice Bromwich during a 3-day hearing in April. And then after 4 months of deliberation, Bromwich delivered his judgment on the 23rd of August. So Justice Bromwich found that it was, before I go to that, so look, this slide, which I hope you can all see both parts of it. So Sal Grover, this is like a summary, really. Sal Grover's attitude is law is supposed to reflect reality, and in reality, this person is a male, whereas Bromwich says the acceptance of Ms. Tickle is correct. The acceptance that Ms. Tickle is correctly described as a woman is legally unimpeachable. So there we have the stark difference between the two perspectives. Just to be warned that both the language and reasoning adopted by Bromwich demonstrated an uncritical embrace of gender identity ideology as propagated by both Tickle's legal representatives, but also the Sex Discrimination Commissioner. For example, Bromwich acknowledged at the outset that the term cisgender does not appear in the discrimination legislation and was opposed by the respondents, the Giggle team, and yet he proceeds to use this term no less than 30 times in his judgment without any sort of particular reflection really about that. Now, of course, Sal's view that the law should reflect reality sounds sensible, but those of us who are lawyers know that the law is full of legal fictions. So a legal fiction is a construct used in law where a thing is taken to be true when it's not in fact true. And this is done to achieve a certain outcome. I won't go into this. I've put a few on the screen, if you can see that slide, of some pretty well-known legal fictions. I would suggest that the courts need to consider really closely the implications of adopting these fictions. The law really rests on the telling of the truth, and I think we should, the legal system should lead by example. But it seems that at the moment, the law doesn't think reality should get in the way of a good legal fiction, to sort of paraphrase a quote from, I think, Mark Twain, who said the facts shouldn't get in the way of a good story. So lawyers have a similar view, it seems. So back to the details. So Judge Bromwich found that it was not established by the evidence that Sal Grover was aware of the applicant's transgender status. So when she took the decision to block Tickle, she did not know that Tickle was transgender. So accordingly, Bromwich found that there was no direct discrimination on the ground of gender identity because it just hadn't been proved. So that was a complete answer to the claim of direct discrimination. However, Bromwich then reasoned instead that Miss Grover had imposed a condition, the condition of needing to appear to be a cisgendered female in photos submitted to the Giggle app, and that this had the effect of disadvantaging transgender women who did not meet that condition, and in particular Miss Tickle. So that I'm quoting there from the judgment. So on this undisputed basis, Bromwich made a finding of indirect discrimination, despite observing that it hadn't been properly pleaded in the first place by Tickle's legal representatives. Throughout the judgment, Bromwich makes fair criticism of the pleadings and the conduct of the proceedings by both parties' legal representatives. So specifically, he complains that Tickle's pleadings do not coherently distinguish between direct and indirect discrimination. Bromwich also notes that the respondents failed to identify this shortcoming or to object to the amendment of the pleadings in this regard. So despite this failure to plead Section 5B2 clearly, the judge kind of works to correct this deficiency so that he can ultimately support his finding of indirect discrimination. So the court's less helpful when it comes to repairing the shortcomings of the respondent's case or the Giggle case. A claim of indirect discrimination enlivens another section, Section 7B, which provides a defence when the condition imposed, the condition, requirement or practice, that is reasonable in the circumstances. So unfortunately, the onus to establish that rests on the respondent. So they have the burden of satisfying the reasonableness test. Unfortunately, no doubt because they perceived the case as one of direct discrimination, the respondents failed to plead Section 7B and did not rely upon this defence in their submissions. Bromwich didn't repair this shortcoming, despite the fact that really the respondents could have won the case really by default had he taken an equally rigid approach to the failures of Tickle's legal team. The evidence in the proceedings provided an ample basis for the argument that the condition of excluding males did not result in any real disadvantage to Tickle, who had in fact conceded in evidence that he made very little use of the app and he found it boring. Furthermore, multiple affidavits tendered into evidence by the respondents, which appear to have been dismissed in a rather cavalier fashion by Bromwich, but they all provided extensive support for a finding that the condition imposed was proportionate and reasonable to ensure reliably safe single-sex spaces for women free of male harassment. But he didn't give that his attention. So instead of pleading Section 7B, the respondents had relied very heavily on another section, Section 7D of the Sex Discrimination Act, which provides an exception from discrimination provisions for special measures intended to achieve substantive equality. This section enacts Article 4 of CEDAW and makes provision for affirmative action provisions. In other words, you can have discriminatory provisions where they're intended to help a disadvantaged group achieve substantive equality. So things like quotas and affirmative action measures. However, although Bromwich accepts that the Giggle Act may constitute a special measure when it comes to the exclusion of cisgender men, he does not accept it as a shield to guard against claims of discrimination on other grounds such as gender identity. Since Bromwich accepts that trans women fall into a category of women, he cannot countenance the respondent's argument that Tickle was excluded because and only because he was a male. Interestingly, Bromwich does not seem to consider whether there could be a claim made for a special measure on behalf of cisgender women to exclude those who identify as trans women. This is perhaps because cisgender women are regarded as the more advantaged group, despite the fact that their spaces and services are entirely excluded from funding and acceptance if they do not agree to embrace gender identity ideology. Ultimately, the difficulty is that Bromwich uncritically accepted and adopted the submissions of the Sex Discrimination Commissioner, who those submissions were, firstly, sex is not confined to a biological concept. Secondly, sex can refer to a non-binary status and can be changed. Thirdly, the determination of sex can take account of legal and social recognition. And fourthly, the sex discrimination provisions must now be read in the context of the amendments to the Sex Discrimination Act in 2013 that added gender identity protection. So Bromwich accepted all of that, saying that it was grounded in logic and long-standing authority. In contrast, Bromwich finds the expert reports relied upon by the respondents, the Giggle team, as to the immutable nature of sex from both scientific and philosophical perspectives, with reports from both evolutionary biologist Colin Wright and academic Kathleen Stock, to be of no use to the respondent's case. Bromwich also rejected journalist and author Helen Joyce as an expert. He rejected her as an expert altogether, despite her having authored a book on trans when ideology meets reality. But he found that she had no formal qualifications of relevance. He stated instead that she is entitled to her opinion, but it is of no assistance to the respondent's case or to this court. So I suppose we should be grateful for this small concession that she was entitled to her opinion, because we're increasingly in an environment where we feel as if we're not entitled to an alternative opinion on this subject. Increasingly, we're being told that dissent on this topic can constitute hate speech. The respondents, when I say the respondents, I'll just say the Giggle team. The Giggle team also tendered 14 affidavits of lay opinion, ordinary people's opinions as opposed to experts, often on the crucial importance of female spaces, and these were similarly dismissed by Bromwich as having no bearing on the matter. There was no cross-examination of any of the respondents' experts or lay witnesses. Instead, the court relied on case law going back over 30 years, which Bromwich states has broadened the concept of sex, leading him to claim the acceptance that Ms. Tickle is correctly described as a woman is legally unimpeachable. Strangely, Bromwich didn't enter into any detailed analysis of the case law in question, despite it really being at the crux of the case. He just simply accepted the submissions of the Sex Discrimination Commissioner, and we're really left curious whether he had an independent view of the authorities cited. Of course, there is another section of the Sex Discrimination Act which was completely, was not pleaded and received no attention in the judgment, and that is Section 32, which states that discrimination provisions do not apply to the provision of services, the nature of which is such they can only be provided to members of one sex. I would think that that could provide specific protection of the kind needed by the respondents, but this provision was, of course, going to be rendered inoperable by a finding that Tickle was a female. So basically the respondents had argued that Tickle was excluded on the basis of sex rather than gender. That argument was rejected because Tickle was accepted as being a woman, and that his claim was on the basis of gender identity. Tickle was not claiming to have been treated less favourably than a man. Tickle was complaining about being treated as if he were a man. So a key defence of the respondents was to challenge the constitutional authority for the 2013 amendments to the Sex Discrimination Act, which introduced the protection of gender identity. The Giggle team argued that CEDAW does not extend its protections to gender identity, only to sex, and therefore the amendments are not supported by the External Affairs head of power under the Australian Constitution. But Bromwich found that CEDAW just wasn't relevant at all because the Convention does not extend to protecting one category of woman from another category of woman. And because he'd found that Tickle was a woman, therefore it had nothing to do with CEDAW. Instead, Bromwich referred to the fact that the gender identity provisions are supported by the more broadly worded Article 26 of the International Covenant on Civil and Political Rights. This article protects against discrimination on various grounds, including other status, which Bromwich was convinced does include gender identity. So he dismissed the respondents' arguments that Article 26 is too general and vague to be relied upon, and accepted that. In any case, Bromwich also found that Giggle is a trading corporation. And in fact, as a trading corporation, the Commonwealth can make laws in relation to it under another head of power under the Constitution, really rendering all these arguments in relation to the external affairs power somewhat redundant. There was a second constitutional argument that was put. This one, it related to there being an inconsistency between the Federal Sex Discrimination Act and state laws which allow for change of sex on birth certificates. The idea is if there's a state law that's inconsistent with the Commonwealth law, then it's going to be invalid to the extent of that inconsistency. So the Giggle team argued that, in fact, being able to change sex created an inconsistency with the protections of sex under the Sex Discrimination Act. However, of course, the 2013 amendments somewhat undermine this argument since they removed the definitions of man and woman. But Bromwich said that even if those definitions had remained, there would be no inconsistency because the Sex Discrimination Act is not exhaustive and it does not impose its definitions on the states. So even if we had those definitions put back in, which I think Claire Chandler was attempting to do at one stage, it wouldn't be a problem. So the bigger problem that we have is that the states have now almost, basically all of them have now allowed for change of sex on birth certificates. So Bromwich really dispensed with all these arguments really quite quickly with really very little angst, considering the complex constitutional and philosophical considerations about the nature of sex and its protection. But he then spent 10 pages of his judgment on a detailed legal analysis in relation to the assessment of damages. And that's quite peculiar considering that Tickle didn't put on any expert evidence to quantify the loss claimed. He didn't put on anything from a doctor as to the exacerbation of his pre-existing psychiatric condition, and generally failed to provide specifics or justify seeking the amounts of $100,000 in general damages and $100,000 in aggravated damages. However, the Giggle team can be grateful that by rigid application of a certain section, I won't bore you with, Bromwich found that it was inappropriate to make any award of aggravated damages. Basically, we're saying that the complaints that related to actions that took place after the lodgement of the complaint shouldn't attract damages because they weren't part of the original claim. So instead, the court ordered a payment of only general damages in the sum of $10,000. So this is considerably less than Tickle's ambit claim, but it's still arguably a grossly excessive sum for findings of modestly hurt feelings and the loss of access to a social media app, which he admitted to having made minimal use. So Bromwich recognises this was a case brought on principle rather than due to any lasting hurt or disadvantage. So really should have acceded to the respondent's submission that an award of damages should be nominal. Due to the complete lack of evidence and precedent upon which to base an assessment of the quantum of damages, Bromwich relied instead upon an instinctive synthesis to make his award, and after considerable thought and reflection, reached into a hat and pulled out $10,000. It's to be wondered whether that thought and reflection included considering that $10,000 is the maximum recognition payment available to women in New South Wales who are primary victims of sexual assault resulting in serious bodily injury or multiple offenders or an offensive weapon, etc. So I don't know, but perhaps it was Ms. Grover's conduct in court laughing at an offensive caricature of the applicant that convinced the court that this offensive and belittling behaviour should result in an award commensurate with the amounts paid to victims of violent sexual crime. I don't know. However, this was that would be arguably inconsistent with the statement made by Bromwich at the outset that the court has power only to compensate, not to punish the respondents. In any case, the award of costs against the respondents is definitely going to be far more punishing than the compensation to be paid to Tickle. And these awards are awarded by the court despite not having been originally sought in the applicant's pleadings, and they're only partially capped. The cap of $50,000 only extends to the work that was involved in the constitutional and statutory construction arguments, not to all aspects of the case. Originally, there had been, the applicant had floated a general cap on costs of $20,000, but unfortunately that was rebuffed at an earlier stage by the respondents' team. Sensibly, Bromwich declines to order a forced and insincere apology or to order Tickle's reinstatement to the now defunct social media app. The wording of the declarations to be made in Tickle's favour are yet to be finalised after consideration of proposed wording by the parties. And that's the end of my slides. So look, just to conclude, Bromwich now has the very dubious honour of being the first judge to decide that it is possible to change sex in a context where the result of his decision is to directly destroy any prospect of women and girls continuing to enjoy safe single-sex spaces and services. While laughable in its reasoning, the implications of this decision are no laughing matter. I think I'll stop there. Thank you.